Hi, my name is Steven Cras. I'm a Dutch national, but I work for the Council General Secretariat in Brussels in the field of criminal law. I will tell you something about the work in the European Union on establishing procedural rights for suspects and accused persons in criminal proceedings. I will do this in about 15 minutes. I will say something about the work that we have carried out in the past, the work that we are carrying out now, and about the future developments that we are foreseeing right now. As you know, in the past, the European Union has carried out a lot of work in order to promote cooperation between national authorities in order to combat crime, in order to favor the prosecution of crime. The European arrest warrant is a very good example in this regard. But where this work regarding the prosecution of crime was very, let's say, efficient, the work on the procedural rights for suspects and accused persons has lagged behind. And in order to address this imbalance, the European Commission in 2004 has proposed a directive in order to establish a set of procedural rights for suspects and accused persons in criminal proceedings. The Council has worked on the proposal from 2004 to about 2007, and then the work was abandoned because it was impossible to reach unanimous agreement as was required under the Amsterdam Treaty. But this lack was still felt, and therefore in 2009 the Swedish presidency proposed a new method. They wanted to do a sort of step-by-step approach in order to achieve a sort of catalogue of procedural rights for suspect and accused persons. And this catalogue was set out in a roadmap which was adopted by the Council on the eve actually of the entry into force of the Lisbon Treaty on the 30th of November 2009. And this roadmap sets out about 5 areas in which the European Commission is called upon to present legislative measures. We're talking about the right to interpretation and translation, the right to information on rights, the right of access to a lawyer and the right to legal aid, the right to communicate with consular authorities, and the special rights for vulnerable persons. These were 5 rights, and in addition, the Commission was asked to present a green paper on pretrial detention. This was actually the catalogue which was the basis of the work that we are now carrying out in the European Union on procedural rights, this roadmap of 30 November 2009. The roadmap has also been integrated actually in the Stockholm program, which was adopted by the European Council in 2009 as well, December 2009. So it has also got the blessing of the heads of state and of government. And they added one more measure which they said that should be worked upon, and that is the presumption of innocence. Well, the first measure that the Commission was called upon to present a proposal on was actually already presented in July 2009, and that is about the right to interpretation and translation. And the Council and the European Parliament have adopted a directive in this field in October 2010, and so it's already in the books, in the official journal, and the member states, they are required to transpose that. And now I have to look when that was. That should be done by 27 October 2030. So it was just last year that it had to be done. And apparently this is actually going quite well. We have had some experts meetings on that. The directive sets out the right for suspect and accused persons to have the right to interpretation in criminal proceedings before investigative and judicial authorities, during police questioning, and all court hearings and any necessary interim hearings. And you also have the right to interpretation if you have to speak with your lawyer when that is necessary in the context of the criminal proceedings. Moreover, you have the right to translation under the directive of essential documents that are necessary in order to exercise your rights of defense. The essential documents is said in Article 3 of the directive include any decision depriving a person of his liberty, any charge or indictment, and any judgment. And then on top of that, the judges can say that other documents are also essential documents which have to be translated for you. Where appropriate, in exceptional circumstances, an oral translation can be provided of essential documents. For example, when a document is produced during the hearing and you like to have a quick translation of that. The costs of interpretation and translation are to be borne by the member states, and there's also something said in the directive about the quality of the interpretation and translation. So that directive has already been transposed by the member state, or should already have been transposed by the member states, and the European Commission at the end of this year will be competent to bring member states to the European Court of Justice in Luxembourg if they have not fully complied with this directive of 20 October 2010. That was the first measure, Measure A, on interpretation and translation. Measure B, that's about the right to information in criminal proceedings. And that directive has also been adopted on the 22nd of May 2012, and it has to be transposed by the member states in their national legal orders. I have to speak by 2 June 2014. And this directive actually has two chapters. One chapter is about the right to information, and one chapter is about the right of access to the materials of the case. Well, the first chapter is about the right to information. When you are a suspect or accused person, you should be promptly informed that you have certain rights. Because if you know what your right is, then you can better exercise it. And the 5 rights where you should be informed about all suspect or accused persons, whether you're deprived of liberty or not, are the following: the right of access to a lawyer, any entitlement to free legal advice and the conditions, how you can obtain it, the right to be informed of the accusation, the right to translation and interpretation, and the right to remain silent. So these 5 rights you should be informed upon as promptly when you are a suspect or accused person. And the promptly then is the moment in time that you can effectively exercise your rights. When you are deprived of liberty, that means when you are arrested or detained, you should also be given a written letter of rights in which these 5 rights are set out, plus some other rights. And the other rights are the right of access to the materials of the case, the right to have consular authorities and one person informed, the right of access to urgent medical assistance, and the maximum number of hours or days that you can be deprived of liberty before you are brought before a judicial authority. So all these rights, the 5 first ones and the 4 extra ones, have to be set out by member states in a letter of rights, which you get a copy of and which you may keep in possession during all the time that you are deprived of liberty. It's a bit the same as you have in some member states already, and this letter should be produced in languages that the person can understand. So a lot of member states have already made 40 or 50 different language versions of this of this letter of rights. Then you should also have the right to information about the accusation, and you have also the right of access to the materials of the case, and this is all set out in this directive on the right to information. It was adopted on the 22nd of May 2012, and it's also published in the official journal. Then we come to the third measure, that is the directive on the right of access to a lawyer. This was measure C actually in the roadmap, but in the roadmap it's also said that it is about the right of access to a lawyer and about the right to legal aid, which is accompanying the right of access to a lawyer. But in this directive, which we have now already adopted, following a proposal of the European Commission, we have only dealt with the right of access to a lawyer, but we have also added measure D, and that is the right to have a third party informed about your deprivation of liberty and to communicate with third persons and with consular authorities when you are deprived of liberty. It's a very important directive, this directive on the right of access to a lawyer, because it actually puts black on white the Saldus case law of the European Court of Human Rights in Strasbourg, and it provides more detail. Very important. In the directive, it is said when you have the right of access to a lawyer as a suspect or accused person in criminal proceedings, and it is said that you should have the right of access to a lawyer without undue delay and in any event before any of the following acts, and that is then before you are questioned by the police or by another law enforcement authority, upon the carrying out of an investigative or other evidence gathering act, and then we are talking about identity parades, confrontations, reconstructions of the scene of crime, without undue delay after deprivation of liberty, and when you are summoned to appear before a court having jurisdiction in criminal matters. So before any of those four events, whichever is the earliest, you have the right of access to a lawyer. And then we have put some small possibilities to derogate from this right of access to a lawyer. And we have also set out what are the obligations actually of the member states. And when the persons are not deprived of liberty, when they are at large, member states should endeavor to make general information available to facilitate to obtain a lawyer. But when you are deprived of liberty, member states should make the necessary arrangements in order to ensure that you can effectively exercise your right of access to a lawyer. Member states should also respect the confidentiality, actually, of communication between suspect and accused persons and their lawyers. That's Article 4. And then Article 5 and 6 and 7, they deal with the right to have a third person informed of deprivation of liberty and to communicate with consular authorities. Another important provision of this directive on the right of access to a lawyer is the right of access to a lawyer in European arrest warrant proceedings. According to the framework decision on a European arrest warrant, you already have the right to a lawyer in the executing state, but this directive also gives you the right to a lawyer, to appoint a lawyer in the issuing state in order to help the lawyer in the executing state to assist you. Legal aid, that's all left to national law, basically. And we have said something about vulnerable persons, that the particular needs of vulnerable persons should be taken into account in the application of this directive. Very important directive. It has to be transposed by the member states in their national legal orders by 27 November 2016. So that's another almost 3 years, but it's will entail a lot of new legislation in the member states, and so therefore these 3 years are very necessary actually. So this is what we have done. Measure A about the right to interpretation and translation, measure B the right to information, and measure C, let's say, the right of access to a lawyer. And now we are working in the Council on measure E, and that's about vulnerable persons. The Commission has made a proposal on that issue, and it has singled out children as the main topic there. So we're talking only about children as vulnerable persons, and we are giving them special rights which are based on these first three measures, A, B, and C. And together, this will then enhance the rights of children in suspected or accused children in criminal proceedings. Afterwards, we can also work on two other proposals that the Commission has already presented. It is the Presumption of Innocence. There's a proposed directive on, and a directive on legal aid. That's a slimmed down version of legal aid only in urgency cases. So that's what the plans are for the future and what we already have done. I hope this was of use to you, and if you have any query, any question, you can always contact me. It is steven.cras, C-R-A-S, and then @concilium.europa.eu. Thank you very much.